Good morning.
Good
Morning, Your
morning.
Honor.
Okay, I have a few matters to get through and then a couple of matters that I think will take a little bit more time. So I'm just going to run through the calendar. Do I have Mr. Rogers here on the J.G. Wentworth matter?
Yes, good morning, Judge.
Good morning, Mr. Rogers. Is your client, or I'm sorry, not your client, is Kimora Mitchell here?
Yes, ma'am.
Okay, hi there. I'm going to get to you guys in just a second and y'all will go first. Just wanted to let you know I'm going to call the rest of the calendar now, Mr. Rogers, okay?
Thank you, Judge.
Thank you. Shine Investments.
I'm here.
Good morning, Your Honor. Brian Henderson, Tim Gilmet, and Erica Fritz, and Tanya Tuttle here on behalf of Shine Investments.
Good morning, Your Honor.
Good morning. I think I got Miss Tuttle and Mr. Gilmet and Mr. Henderson, and it was Miss Fritz that I missed. Is that
The
right?
most important of them all, Your Honor.
Okay. And who do I have here on behalf of the defendant, City of Atlanta?
I'm Robbie Ash, Your Honor.
Hi, Mr.
Good
Ash.
morning.
And Mr. Varghese?
Varghese, yes, ma'am, Your Honor.
Varghese, thank you. I'm going to get it right eventually, sir.
That's okay.
And we have our
Matthew
colleague.
Sellers,
Yep.
also
there
on
we go.
behalf of the city.
And Mr. Sellers. Okay, and I know part of the issue that one of the issues of the 8,000 that you guys have filled my inbox with that we're going to sort out today is no one's here on behalf of Kissburg Construction, or is there someone here on behalf of Kissburg Construction?
And I am the court reporter they asked me to take this one down.
Thank you, Ms. McHugh. I am going to call that one last for obvious reasons, but it shouldn't be too long from now because the other matters I think are a little faster.
Okay.
Your Honor, do you mind if we turn off our video while we're
No,
waiting?
not at all. I'll let you know. I'll holler out when I'm ready to get started on that one.
Thank you.
Thank you. P3 Real Estate. Do I have anyone here on that matter? Obviously, I've granted summary judgment and received a proposed order. So I thought you were excused, but in case you're here. Okay. Jean-Marie Polonese, I'm sure I've mispronounced that, versus HDM Group. Who do I have here on behalf of the plaintiffs?
Your Honor, Matt Matson on behalf of the plaintiffs, and you actually got it perfectly right.
Oh, okay. Yay, gold star for me. It's a good way to start my day. Who do I have here on behalf of the defendants?
Good morning, Your Honor. Justin White for the defendants in this case.
Okay. Mr. White, I don't mind you being in a car, but you're not moving, are you? Like that's not safe.
I'm not, Your Honor.
Okay. Just making sure. Okay. And so I've gotten a number of emails from you. I appreciate your CPTO having been submitted. I think there was some discussion about scheduling from you guys in terms of readiness for trial and maybe some motions. What would generally give me an overview of y'all's case? Because I haven't needed to talk to y'all much before now because y'all were out there just doing your own thing and conducting your discovery. So, Mr. Matson?
Yes, Your Honor, my clients are ready and prepared to go to trial. I know that Mr. White filed a motion for continuance late yesterday. I have not had a chance to discuss that with my clients yet. I also understand that Mr. White is going to be changing law firms, and so someone else may be taking over this case, but I haven't gotten much direction on that, and I don't know if he can enlighten us on what the plans are.
Mr. White?
Your Honor, my firm has not told me exactly which attorney is going to be taking over the case once I leave. They've narrowed it down to 2 attorneys, but they're not sure which one is going to be taking over, but someone will be taking over the case.
Forgive me, Mr. White. What firm are you with?
John B. Miller and Associates.
Okay. And is that the reason for the requested continuance?
That is one of the reasons for the request for continuance, Your Honor. The second reason is actually the fact that we have been in this case since at the very least February when we filed our answer. But upon checking the docket and looking at some of the things, I realized that I was actually never added to the case in Odyssey, so I haven't been receiving the pleadings, and I've actually only about things upcoming because Mr. Matson sent emails.
Okay, well,
So
that's
once we-
good. Not for nothing, Mr. White, and I don't want to throw you or your staff or anything under the bus, but you do know it's your job to be filed to add it into Odyssey, correct? Like, I mean, you or your staff or your firm, correct?
Yes, I understand, Your Honor.
Okay. Okay. So what, other than your announcement, Mr. Matson, that you are ready to go to trial, what are your thoughts on the requested continuance?
Well, I do not want to put defendants in a bad position. I will say, without going into any detail on settlement discussions, we're much closer in the last 24 hours than we have been. We
Mhm.
mediated about 2 weeks ago. I think having this on the trial calendar, as is common, has gotten the clients and the parties more focused on this. And I think that if we keep it on the calendar, and I would, like to hear Mr. White's thoughts on this, but I think we could get our clients together on something. But if we kick it down the road, we're all busy and we'll all move on to the next thing. And, again, I don't want to put them in a tough spot if they're changing lawyers, but my clients are ready to go. And I think we can, maybe sharpen our pencils and get this thing resolved, but.
Okay, thank you. I appreciate that. If you guys will sit tight, I'm going to run through the rest of my calendar and give that a little bit of thought, and I'll be back with you guys, okay?
Thank you.
Thank you, Mr. Matson, Mr. White. Marvis Johnson versus Marta.
Judge, they're scheduled for a 10 a.m. appearance.
Oh, that's right. Thank you. And then everybody else is 1 or 2. Okay. So then I'm going to go back around. Mr. Rogers, are you ready? And is Ms. Mitchell ready?
Yes, Your Honor, I'm ready.
Okay, if you'll go ahead, sir.
Thank you, Your Honor. Ms. Mitchell, if you can please unmute yourself.
Yes,
Thank you. And can you raise your right hand, please, ma'am? Do you swear that the testimony you will give before this court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you state your name, please, ma'am?
You can put your hand down, ma'am.
Oh, Kimora Mitchell.
Do you live in Fulton County?
Yes, sir.
Are you married?
No.
Do you have any children?
Yes, sir.
How old are your children, ma'am?
I have a daughter. She's 9 months.
And did you enter a contract with J.G. Wentworth to transfer payments of $9,950 that come due in August of 2026, 2027, and 2028, and also 2 other payments of $9,950 that come due in February of 2027 and February of 2028?
Yes, sir.
And do you understand that all those payments you're giving up total $49,750?
Yes, sir.
And do you understand that they've got a discounted present value of approximately $45,607.10?
Yes, sir.
And you've agreed to receive one lump sum payment of $33,700. Is that correct, ma'am?
Yes, sir.
And do you understand that that amounts to an effective interest rate of about 24%?
Yes, sir.
Ms. Mitchell, were you given the chance to speak with a lawyer or a financial advisor? And did you waive that right in writing?
Yes.
Did you get a copy of the petition and the hearing notice 20 days ago?
Yes, sir.
And Ms. Mitchell, are you sure this is something you want to do?
Yes, sir.
Tell the judge what you wish to do with the funds if she approves this transfer.
What I wish to do with the funds is to put down on a new vehicle for to get around to work, and also I would like to start a business and put down for a home for me and my daughter, and the remainder of the funds I will use it like to buy my daughter, Pampers, just living expenses for me and her.
Your Honor, I have no further questions.
Okay. Ms. Mitchell, so I don't know the extent to which, Mr. Rogers appears in front of me frequently in these types of matters. And so I trust that he's made sure that you are informed about what your rights are. And probably he's told you a little bit about what the procedure is. But the reason we have hearings like this is because it's my job to make sure that you understand that this money has a great deal more value if you wait for it to be given directly to you in, it looks like, periodic twice a year payments in February and August over the next few years. And that you are giving up a substantial amount of money. It's a large interest rate that Mr. Rogers just referenced. To have that money in your pocket now rather than waiting to get those periodic payments. Do you understand that, Ms. Mitchell?
Yes, Your Honor.
Okay. And can you tell me, so a lot of what you have outlined, right, are things that perhaps you could use the individual lump sum payment of $9,000 in a February or August to pay for. Certainly not to take care of your daughter on a routine basis. But can you tell me a little bit about why you feel like you need the lump sum now as opposed to waiting for those smaller lump sums, but that come in periodically?
Well, first, the vehicle situation.
Mm-hmm.
I just need to get around because Uber and Lyft is is hard to save when you just spending money on Uber and Lyft. And then another reason is a living situation. I want to move out. I want me and my daughter to have a home,
Mm-hmm.
and that's pretty much it. And the business. I want to be a lash tech, so a lash business. I want to
That's a big business right now. That probably is a
Yeah.
good field to be in.
Yeah, so I don't want to work the 9 to 5s. I want to have a career,
Okay.
The business it will be a first start.
Okay. Mr. Rogers, I'm looking at your app, your filing, and obviously I know this was originally, these payments arose out of a structured settlement. I am looking quickly and not finding, is this a complete liquidation or is it a partial liquidation?
The short answer is I don't know. Judge, I'm going to try to pull up what information I have, and I might be able to. I don't think I have a copy of the annuity. And
Well,
so
you
I don't.
usually tell me when it is a partial, and that's why I was assuming it was a complete liquidation, because your applications typically say there are remaining payments, but
My understanding is that this is the first transfer Ms. Mitchell has done.
Mhm.
They are not often complete liquidations, although
Okay.
sometimes they could be. But I don't have in front of me information that would give me the answer to that question. Ms. Mitchell might know.
That was what I was going to ask is, Ms. Mitchell, do you know if whatever structured settlement you have annuity that you would be entitled to other periodic payments in, say, February and August after 2028 that you'll still be receiving and that you're not cashing in right now?
Yes, ma'am.
Okay. And out of curiosity, do you know how are those for life? Or are those for a certain period of years? Do you know?
Certain period.
Okay. Okay. Thank you, Ms. Mitchell. So I ask a lot of questions, and it's just because, as I said, Ms. Mitchell, it's my job to make sure that you have some understanding that I understand that you need the funds now, and you have stated the reasons that you want the funds, and it's your right to do that. It's just my job to have that extra procedural step to make sure you have had a chance to think about it and understand the ramifications of it. But I am satisfied that Ms. Mitchell understands and intends to go forward with the transaction, and so I will approve it, Mr. Rogers. I have your proposed order that I am looking at now, and it indicates that the court will authorize the transaction of the semi-annual payments of $99.50 for August of 26 through August of 28. And it looks like Ms. Mitchell has already signed that document. and I will sign it for you today and get it on file. Anything else you need from me, Mr. Rogers?
No, thank you, Your Honor. May the parties be excused.
Yes, thank you, Ms. Mitchell. Good luck to you.
Thank you.
Thank you so much.
Have a good day.
You as
You as
well.
well.
Okay. Mr. Matson, Mr. White, if you guys could come back for just a minute.
Yes, Your Honor.
Mr. White, you there? He's probably trying to get stationary. Oh, nope, now we're in a building. Okay. And I please don't think I'm mocking you. I see lawyers move backgrounds all the time because we're all trying to be in 9 different places at one time. So I totally understand. Mr. White, I am, I think I agree with Mr. Matson that I don't think anybody wants to put you or your clients in a bad position. But I also think that the motivation to get the case resolved short of trial is a good one. And that sometimes having that trial date is the motivation that everyone requires. Currently, this matter is on, I think my criminal trial calendar is Monday, the 17th. We'd be picking a jury on Tuesday, the 18th. In full candor, I have another matter that is likely ahead of you guys in terms of age. And so I'm not sure I would reach you, but for now, we're going to see if I do. And so I think what I will do is encourage you guys to continue the good efforts of trying to resolve the case. Maybe you do. If you are not able to resolve the case, I will know midweek next week, probably Wednesday or Thursday of next week, confirmed if the gentlemen that are also on this call are going, and can let you know that you will not be going, or y'all can let me know that you've resolved the case. If it doesn't go, then it will be on the pretrial conference calendar for, I think it'll be December the 4th.
Okay.
Okay. Now, you guys did satisfy what my requested obligations were, which was for you to file a CPTO. Everything that I saw looked in order. And I did see a couple of motions in limine. I do require them to be filed with the PTO because that way I think it gives the parties, and I want the parties to do as much work as is reasonably necessary to really meaningfully think about what their case looks like and what they're going to be arguing about at trial. So you can make informed decisions about whether to resolve those motions or resolve the case entirely. But my intention is, unless you have questions for me, what I will likely do is, if you are going to go to trial the week of the 17th, I would likely have you in on the 14th for a, either the 13th or the 14th for a pretrial conference, or actually I take that back. I'm sorry. Monday, the 17th, I could potentially have you guys at 9 o'clock for an actual pretrial conference to talk about the substance of the case. Or we would do it all over again on the 4th of December. In the interim, it is still my intention to enter the CPTO that was proposed, unless the parties have any questions or concerns about my doing that. And that is merely to preserve the status quo in terms of, changed pleadings, et cetera. What are your thoughts, Mr. Matson?
Your Honor, the only thing that I think we'll need to change on the pretrial order is going to be subject to Mr. White once they figure out which attorney is going to be trying it.
Okay.
But otherwise.
But your firm is listed, correct, Mr. White? It's Justin White and the law firm of John B. Miller. Is that right?
That's correct, Your Honor.
Okay. And so I think that will be an easy one that can be remedied in terms of having someone parachute in if that's what is going to occur. Any questions or concerns for me, Mr. White, regarding the consolidated pretrial order entry?
No, Your Honor.
Okay. Well, then I will get that on file for you guys, and we will be in touch middle to end of next week to let you know if the case is going, or if the rest of I mean, as you see my very full Zoom screen, all of those people are about the other case that I need to deal with that is also on that calendar. So we will be in touch to let you know which one is which. I wish you, Mr. White, the best of luck as you move on to other, opportunities, but I also wish you both the best of luck in attempting to possibly resolve the case. Since you're both, it's top of mind and it's on the front burner and all those other good metaphors that we use. So, okay.
Thank you, Your Honor. May I be excused?
Yes. Thank you, Mr. Mattson and Mr. White. Have a good day.
All right, you too.
Thank you, Your Honor. You as well.
Okay. Gentlemen that are here for the Shine matter, if you'll give me about a minute, I'm going to get a fresh cup of coffee and then it's 9:21. I'll be back at 9:25 and we'll get started. Okay. Good morning. Madam Court Reporter, we're going to go ahead and go on the record for pretrial conference in the matter of Shine Investments versus the City of Atlanta and Kissburg Construction. Case number 2023 CV 382285. Before we went on the record, I got announcements from counsel for plaintiff are here, Mr. Gilmet, Mr. Henderson, Ms. Tuttle, and Ms. Fritz. And counsel for the defense, or correctly, the defendant, City of Atlanta, Mr. Ash, Mr. Varghese, and Mr. Sellers. And Kissburg Construction is not present, is my understanding. Okay, so we are here on a pretrial conference. Before we get to that, I think there's some preliminary matters we need to work through because, as I said, I have 30 emails from the parties with various filings. I've got some motions to quash, some notices to produce or subpoenas to appear for deposition. I've got, I think the most interesting one that we probably need to work through before I enter a CPTO is what of Kissburg Construction's status. I did read the motion and reviewed my docket in the sense of, obviously, I believe what happened is I found Kissburg to be in default a long time ago, but that because the case was continuing and the matter of damages was open, that I did not reduce. I think I entered an order of default, but did not reduce that order of default to a judgment of default pending evidence of the damages in the case. I also will note that that order of default was entered as to certain counts that existed prior to an amended complaint because as I argued with the Court of Appeals once, you can't be in default on an amended complaint for some reason that absolutely escapes me, except that the actual statute says you don't have to answer. So, but that's probably an event for another day. But that's what I believe the procedural posture of Kissburg to be. What I understand now is that the defendants have asserted that Kissburg was never notified of the continued ongoing proceedings, and therefore they have a right to appear, and yet they are still not here. So I think that the motion here is a motion to sever Kissburg, but I actually question. I think we need to talk a little bit about the extent to which Kissburg actually exists in the case, such that they need to be severed in terms of how the case would be presented to the jury. So with that, I do want to start with that motion unless anyone says we shouldn't do that. Okay, so who am I going to hear from for the defendants who filed that motion?
Your Honor, Sachin Varghese for the City of Atlanta.
Okay, Mr. Varghese, if you want to very briefly go ahead, because we do have a lot to try and get through this morning, and I have another matter at 10 and then a criminal calendar at 10:30. So go ahead, sir.
Yes, so I think you've summarized the factual background correctly. There was default on the original complaint. There was an amended complaint filed asserting new claims, and for the first time, claims for damages. That amended complaint was never served on defendant Kissburg. Petitioner City of Atlanta, respondent, has moved to sever under 91142B, which obviously is to the discretion of the trial court. But both bases for severance in 91142B, both convenience and to avoid prejudice, merit severance of Kissburg here, and I can address that. But the second point is it would be reversible error to go to trial on any of these issues against Kissburg. And if the court would like me to address that issue first, I'm happy to do that. Otherwise, I'll start with severance.
I would like for you to answer that second issue, but first let me ask this question, and forgive me if it seems like a dumb question, but isn't Kissburg the construction company that the City of Atlanta, if I'm recalling these facts correctly, the City of Atlanta retained Kissburg Construction to tear down the building, and allegedly Kissburg Construction called the City of Atlanta and said, hey, There's been improvements here. What's going on? And the city of Atlanta directed Kissberg to tear down the building. I'm sure there's probably lots of disagreement about those core facts, but the reason I lay them out is the jury's going to hear a lot about Kissberg Construction's role in this case, are they not? Or is it because of the summary judgment that they're not really going to hear about Kissberg because all we're going to talk about is the value of the building?
Yeah, so without Kissberg, all we're talking about is the value of the building, right? We've already found liability against the city for inverse condemnation of the building. The only question is, what's the value? With Kissberg in the case, there are unique claims asserted against it, including conversion, trespass, seeking attorney's fees, and from the PTO, punitive damages. And so those open a host of issues and require evidence that, one, is unnecessary to try the case with regards to what is the value of the building at issue, but two, are also prejudicial to the city of Atlanta to have those issues in our case, and three, will just expand the scope of the case if all those issues have to be tried when none of those are necessary to resolving the claim against the city.
Mr. Verghese, let me interrupt you for just a moment and ask, who on the plaintiff's side would I hear from about this matter? Because it's sort of, given how fresh and new it is in terms of the filing, there's a universe in which the plaintiff says, okay, we agree. What say you, Mr. Henderson?
Well, Your Honor, I have a solution that's not quite we agree, but is somewhere close to it. The fact is that Kissberg has been served, is my understanding, though not through hand delivery or sheriff service, but was served subsequently with the amendment to the complaint. They are in default. They certainly had notice of the initial complaint being filed against them and have been contacted regarding today's hearing and still are not here. I think that the court has broad authority to hear the issue of damages. We've already granted a default against Kissberg. I think that default can be extended to liability based upon their failure, assuming they fail to appear at trial, and so we would ask the court to do that. In that respect, I don't think severance will be necessary. I think we'll simply have a default against Kissberg, which solves sort of a lot of those issues. The second part of that, Your Honor, is that I think a severance makes sense should Kissberg show up ready for trial. But I don't think that severance has necessarily the effect that Mr. Verghese is suggesting it does. As the court pointed out, we will have to talk about the process of the demolition. We'll have to talk about what Kissberg did. But that's especially important here, Your Honor, because the city of Atlanta is disputing how complete the buildings were, how finished they were at the time of the demolition. And so the evidence about Kissberg, not once, but multiple times, reaching out to the city and saying, I don't think we are supposed to move forward with this demolition. There's fresh asphalt, there's repairs, there's electricity that's been hooked up, is something that will come into the case.
What notice do I understand that Mr. Verghese, Mr. Verghese, I'm going to come back to you. Thank you, Mr. Henderson. Because as I understand it, and Mr. Henderson has reiterated or reminded the court that part of the issue about the notice that Kissberg had is whether they were properly served with the amended complaint, et cetera, and that they didn't consent, but they also, I believe that the law is that they waive if they don't appear. Factually, whether it's proper or sufficient, what knowledge do the parties have about what notice Kissberg Construction has received of these ongoing pleadings, whether they acknowledged it or whether it was sufficient legally or not?
So, Your Honor, I had a conversation with a representative for Kissberg yesterday, informing them of the pretrial conference today and trial schedule for the 17th, and suggesting that they retain counsel Mr. Henderson asserts that they've had notice. There is no evidence in the record that they were properly served with the amended complaint. And typically, failure to
Well,
respond.
Forgive me, sorry to interrupt, Mr. Verghese, but that's actually not my question. My question is, what evidence is there that Kissberg received notice of these proceedings? Not the filing of an amended complaint or a proper service, but notices of the various hearings that they have not appeared for.
I don't think there's any evidence of that other than what I'm representing to the court, which is I informed them yesterday of today's hearing.
Okay. That was my only question. You answered it. Please continue, Mr. Verghese.
And to address another point the court raised under 911-5A, failure to answer a complaint is waiver of notice of all further notices, except, and this is an important exception in there, except services of pleadings asserting new or additional claims for relief, which shall be served as provided by subsection B, the service means for an original complaint. And I think this case proves why that exception is there. The original complaint in this case only sought declaratory judgment and injunctive relief. Kissberg certainly could have gotten that complaint and said, well, okay, I mean, if I'm told not to tear down the building, I won't tear down the building. The amended complaint significantly expands the scope of the claims, and now Kissberg faces potential liability for torts, damages, and punitive damages, plus attorney's fees. And I'll point the court to 3 cases that stand for the proposition that it would be reversible error to move forward in this posture. The first case is Stroud versus Elias. It's 247 Georgia 191 at 192, 193. That's a Georgia Supreme Court case. There, the court held that the defendant in default could not be liable for punitive damages because the original complaint alleged a breach of contract, not a tort, and there was no amended pleading setting out a tort served upon the defendant. Similarly here, no pleadings for damages served upon Kissberg. The second case, Your Honor, is Kellogg Company versus Pinkston. That's 253 Georgia App 190 at 192. There, the allegations in the complaint only arose out of an alleged damages alleged to arise out of an employment arrangement. The damages that were ultimately awarded at a bench trial were for intentional misconduct unrelated to employment. There, the Court of Appeals said that there's no evidence that the defendant had notice as to the additional complaint. And I'm quoting here, in the absence of such notice, the state court magistrate lacked subject matter jurisdiction below for the additional reason that a plaintiff seeking to raise a new cause of action or new claim is required to serve a defendant in default with written notice before such claim may be adjudicated. And obviously that hasn't happened here. The third case I would cite, Your Honor, is Jason versus Gardocki. It's 221 Georgia App 455 at 457. There, a defendant in default had attorney's fees awarded against it following trial, and the court held that the defendant had no notice that plaintiff would seek attorney's fees from the complaint that was served, and that default judgment awarding such fees was vacated as a nullity. There are other Georgia cases that stand for the same proposition, and the default judgment statute itself says that the default can only extend to the claims asserted and for which the defendant has been defaulted. And so all of the additional claims raised in the amended complaint, which was never served on defendant, cannot proceed to trial. Or if it does, it's reversible error, Your Honor.
Okay. Mr. Henderson, I think the one point of clarification I would like from you is that was really the issue associated with the court's order. I think what I did was said, I'll partially grant you a default order because Kissberg was clearly in default of the original complaint. But I think, as I understand, and I haven't admittedly gone back and granularly reviewed the original complaint. But as I understand Mr. Varghese point, the additional claims against Kissberg for which the court declined to enter a default order because it was an amended complaint are the ones for damages. And so I guess my question is, if Kissberg were to show up to go to trial, is it plaintiff's position that is it your intention to present and pursue those other claims that were raised in the amended complaint as to Kissberg for damages?
If Kissberg were to appear ready for trial, Your Honor, then I think we would have to present evidence or agree to sever and continue Kissberg as a separate portion of the case.
Okay. So I think what I want to be clear about is when we're talking about Kissberg, I don't want to confuse that that we might be being muddy about evidentiary issues and relevant factual matters that might or might not come into evidence at trial. But I have to say, I am inclined, even if Kissberg is in default as to the original complaint, that clearly they are not in default as to the new claims. And if the plaintiff intends to pursue those new claims as to Kissberg, I think the city might be right that I might need to consider severing Kissberg out. However, I think that Mr. Henderson's point about what notice Kissberg has and whether or not they are here is a relevant one that I need to look into. So while we've been discussing, I've asked my staff attorney to look into what evidence we have internally in our record that Kissberg was notified of the ongoing proceedings, because as you probably all know, not because of y'all, but because you've heard me say it to other people probably, but all of my hearings are peremptory. And if you fail to appear, all of my orders say that I reserve the right to dismiss you or to strike your answer or to take whatever action. And here I'd have to get kind of creative because Kissberg never answered. And so there's a universe in which I could find Kissberg in default, even on the amended complaint, simply for their failure to appear if they in fact received some adequate notice. But I don't have the answer. But I don't have the answer to that just now. I need to look into my own records. Mr. Henderson.
And the only point I was going to add, Your Honor, is there's no question at this point that they have actual notice. We've sent them notice via mail. Mr. Varghese has said that they've spoken to Kissberg and told them about the hearing. I mean, I understand I understand the court's going to look into it, and I think the case law supports the idea that you have broad discretion to find them in default if they don't show up ready for trial. And at the point where they do show up ready for trial, as I've said, I think we'd have to make that distinction and discuss whether or not they should be severed. But I think that there's a world where the universe of evidence is fairly similar, because we're going to have to explain the condition of the building, which is going to involve talking about Kissberg coming and that whole process.
Okay. And that's hang on, Mr. Varghese, I was going to say, you get the last word because it is your motion. So go ahead.
To the extent it's helpful, Your Honor, the only evidence we've seen in the record of any attempt to actually serve Kissberg subsequent to the original complaint is a notice that was filed on Saturday of serving Kissberg of the notice of setting the trial by certified mail by petitioner. And so I'll say that's the only evidence we've seen. Everything else says that they've been served through electronic e-file service. They haven't consented to it. They haven't filed any pleadings. There's no way they've received any electronic service in the case.
But they also haven't filed a certification that they don't have access to an email address, and that there are lots of problems with what happened here. And it is unfortunate because presumably the city hired a licensed, bonded, and insured construction company, and there's probably an insurance company out there that's getting ready to deny coverage for the wildly inadequate handling of this matter by Kissberg, but that's a matter for another day. Forgive me for interrupting you, Mr. Varghese, but I think my intention is this. I think your motion is well taken, but I think I agree with Mr. Henderson that it's probably premature. Only because I don't know that I have to right now order Kissberg to be severed until I've satisfied myself of what you have represented, which I think you're probably right, Mr. Varghese, that there's nothing that would indicate in the record that Kissberg got notice of the ongoing proceedings, although there probably is something indicating they've gotten notice of these most recent proceedings. There is a universe in which Kissberg potentially shows up for trial, and in which case I think my hand would be forced and I would have to deal with the issue of severance. There is also an issue where now that Kissberg does have notice, they still don't show up for trial, at which point I would be absolutely justified legally and factually in finding them in default and moving on from there. So I think my answer is I'm going to put a pin in that motion, but I will say this, that it is likely that if Kissberg were to appear for trial, that I would likely consider granting that motion. And then we would have to figure out procedurally what that means in terms of trying those cases back to back, Mr. Henderson, or trying them on a different day. But that's, I think, what we're going to do for now with that motion with Kissberg, because now Kissberg's still not here. And right now, I don't have any reason to expect that they're going to show up. The question is just, what notice did they have and what action would the court be justified in taking relative to Kissberg if they don't show up? Okay. Okay. I'd like to now deal with some of the issues of the pretrial notices to produce. Mr. Henderson, I received motions to quash from you for, I think, a request for record, like a records pickup depot, and then an actual depot. At least that's what I sort of understood those two matters to be. Can you very briefly tell me a little bit about what, if I'm correct, that's what you understand them to be?
Yes, Your Honor. So there are, I think, as I understand it, two matters currently outstanding. We received additional subpoenas last night, which we'll have to file motions to quash for subsequently. But the long and short of that issue, Your Honor, is that as we've cited in our motion, our contention is that having failed to do discovery, the city is now trying to get a backdoor means to do the same thing. They've requested to conduct a trial deposition of Shine's lender. They've requested to do that in Pennsylvania. The reason for that is that there is the party is out of state, so they would have to get a domesticated subpoena, properly serve that, and then conduct that deposition. Our contention there is that this is tantamount to reopening evidence. The point of a trial deposition is not to circumvent discovery or to allow a second bite at discovery. It's for situations that are unique to what discovery would otherwise allow. Someone is now out of state for some reason and can't be secured as a witness for trial, or something similar to that, Your Honor. But that's not the case that we have before the court. And so I think in brief summary, I guess, our contention for all of the motions or all of the subpoenas is the same, that they're an inappropriate attempt to reopen discovery. Now, clearly they can subpoena someone to come to trial. They can subpoena witnesses. We don't have any objection to that. I don't think we'd have any basis for it.
Well, they can also subpoena witnesses to show up for trial and to bring documents, even if they're documents that were never asked for, never produced in discovery, and that nobody's ever seen before.
And I don't have any objection to that point either, Your Honor.
Mm-hmm. Well, except that, hang on, sorry to interrupt you, Mr. Henderson, but in fairness, as I read your motion, you do have an objection to that, because what you said was that it would be prejudicial to the plaintiff for the defendant to suddenly get documents on the day of trial that you have never seen before or don't have access to.
Well, Your Honor, I do agree with that in terms of the admissibility of these documents or their ability to be used at trial. And I think we can handle that on a ad hoc basis, depending on what those documents are. So I think that to the degree that those documents are things that the city either had access to or could have access to that we requested from them, that were otherwise not produced in discovery, that have some other objection, I think we can deal with that in the moment. But my principal objection is to the provision of things at these trial depositions. that the city is seeking to take. And so I
Okay.
think,
Thank you, Mr.
Well,
Henderson.
I'm sorry, Your Honor.
No, I'm sorry. I thought you were done, so I was saying thank you, but if you're not done, please go ahead.
No, Your Honor, I was done. I was done, but then I heard you say something and I was trying to respond to that. I apologize. I can't actually see anyone on my screen. It's frozen.
Oh.
And so
Well,
I can hear you.
Your audio and your video are coming through just fine, so I think we're good. Who am I going to hear from for the city on this one?
Your Honor, it'll be me
Mr.
again.
Verghese.
Yep.
What is your response, sir?
So a couple of things. One, the Georgia Code provides avenues to obtain evidence wholly apart from what's contained within the Civil Practice Code regarding discovery, and those are contained within the Evidence Code, which explicitly allow parties to seek testimony for preservation at trial and also to require witnesses to bring documents to trial or hearings. And we're simply exercising our right to do that. The court recognized as much in our hearing last week, which is why I was surprised to see the motions to quash. I don't believe the transcript's been filed with the court yet, but at page 34 of that transcript from the hearing, the court said that we are entitled to do that type of trial preservation evidence and also utilize the Evidence Code. So that's all we're seeking to do here. Petitioners failed to cite a single case that stands for the proposition that we can't pursue what's allowed by the Evidence Code. And the single and only case they have cited is wildly off base, and I'm happy to talk about that.
Is that the one
case.
where it was like 3 years old and?
It was 3 years old. The plaintiff had already taken a 30B6 deposition in discovery. They sought to take an additional 30B6 deposition that was denied by the court. They then sought on the eve of trial to take another 30B6 deposition of the defendant of a witness for which the court said there was no evidence, would not be available for trial, or couldn't be subpoenaed to attend trial.
Okay.
Can
Anything
I
else,
respond,
Mr.
Your Honor?
Verghese?
I'm sorry, Your Honor.
Anything else, Mr. Verghese?
That's all I have, Your Honor.
Mr. Henderson, any response?
Your Honor, I don't understand how the case is inopposite in any way. That's exactly what's occurring here. There was an opportunity for the city to do discovery. They were aware, based on the records that the city has, that there were liens on the property related to Rehab Financial. This isn't an unknown individual to them. They knew who the lender was from the inception of the case based on their own records. They chose not to conduct any depositions. They came to the court, similar to the case we're suggesting that we've cited, and said, we'd like to conduct more depositions. The court said, no, we're not reopening discovery. And now the city's saying, well, that's fine. We're going to do this as a trial deposition to preserve evidence, which is the point of a trial deposition, Your Honor, to preserve evidence for trial, not to somehow circumvent discovery and create a new opportunity. And I would submit the same thing is true here, Your Honor. We haven't had any evidence in the record that Rehab Financial won't appear, has been asked to appear and has refused to do so, won't be available, any of the things that would allow this. So I don't think the case is inapplicable. In fact, I think it's exactly the same scenario we're discussing. What's being suggested here is that you could simply not participate in discovery at all. And then on the eve of trial, everyone who you would have in theory deposed say, well, they may not come to trial, I'm not sure. So here are all these trial depositions. I'm going to conduct all the depositions now. I mean, it's strange credulity, I think, to suggest that this is the appropriate procedure, or is not somehow a way just to circumvent the discovery they chose not to do.
Okay. Thank you, Mr. Henderson. So I generally, I think the problem here is that all of us normally operate. I don't think any one of us has ever tried a case prior to the Civil Practice Act. And all of us usually operate in a universe in which there is no such thing as trial by ambush, and there is a meaningful, usually quite lengthy discovery process. And so in that universe in which we all mostly operate, Mr. Henderson is right that the evidentiary procedures for subpoenas to produce documents are merely, additional cumulative remedies to what already exists in the Civil Procedure Act and the discovery process. But the fact that it didn't happen here doesn't, I think, to Mr. Varghese point, negate the applicability of the evidence code and the ability of a party to exercise the rights that it has under the evidence code to compel the production or, attendance at trial and production of documents that go with it. I think there's probably a universe. First of all, again, I know one of them is for a deposition that's something about Philadelphia, and I don't understand why anybody would be getting on a plane and going to Philadelphia. We're all on Zoom for this hearing. I don't understand why we wouldn't just take that deposition by Zoom. But of course, I haven't heard from those parties, and those parties might have some objection. And if they do, I'll deal with that on an expedited basis. I think there's an outside limit, Mr. Varghese, to what the evidentiary code will allow the city of Atlanta to do. But right now, you're still inside the acceptable universe. But I don't know that you could get much further outside of what you are attempting to do. And Mr. Henderson, I also don't believe we can deal with the issue if something comes up in terms of documents that were unknown or inaccessible to Shine Investments that are produced from some of these notices to produce or subpoenas to produce, then we can deal with that at a later time. But of course, generally, if these are individuals with whom Shine was already engaging in business, then Shine's going to have had knowledge of those documents. And so it's not going to be the same analysis that we would typically do, where my first question is going to be, was this document produced in discovery? Because that's sort of gone out the window here. I guess the point is this, all of that is a long way of saying this. Although the city of Atlanta, by choice and then by subsequent decision of the court, has not engaged in the discovery process, has not initiated that Rule 26, 9/11/26 discovery procedures, that does not limit their ability to use other parts of Georgia's code, including the evidentiary code, to ensure the production of documents that it believes it needs for trial. And it is unlikely, absent some specific information that Mr. Henderson and the plaintiffs might provide me at the time we're having that discussion, that an argument about prejudice, particularly as to Shine's own lien holder, et cetera, would be well taken. But I'm not saying it's a foregone conclusion. That's just going to be my ruling. So for now, I'm going to deny the motions to quash that discovery, but suggest that Rule 20, the evidence code remedies are much smaller and closer, tighter than the discovery procedures. And to the extent that the city wishes to exercise them, they should be reminded that it is a more narrow remedy that is available. But for now, the motions to quash are denied, Mr. Henderson.
Yes, Your Honor. I wanted to make just one last procedural point for the purpose of the record, since it's being taken down.
Sure.
The statute would provide, the evidence code would provide that parties, the individuals who are being sought for these subpoenas, would have 30 days as a statutory deadline to reply. I just want to point out for the record that they don't have that in this situation.
And if they wish to assert that, then they can try to assert that. But ultimately, if they are subject to a subpoena to appear for trial, then they're subject to a subpoena to appear for trial. And unless they request and obtain a protective order or a quashing of that subpoena, they're still obligated to comply and appear.
I understood, Your Honor. I just wanted to add that to the record so I can make sure I don't forget the point for later.
Okay. So I think that leaves us with really I know there's some motions in limine. And first, I would like to thank all of you for not filing what I refer to as the please follow the law, please enforce the evidence code motions. I get a lot of those, and it takes a long time to go through them when really those are not unique evidentiary issues to the case. They are, however, very hefty motions that really are going to require some time for us to roll up our sleeves and plow through. And so what I would like to do today is get through the CPTO so I can get it on file for you guys. Find out if you guys have any procedural or trial procedure preparation presentation questions for me. And then I'd like to have you guys come back on Friday, November the 14th. It will just be us for, an hour, hour and a half to plow through those motions. I will also tell you that if I've not already told you, November the 17th is my civil trial week, but my actual jury day is the 18th of November. So this case, we would actually select the jury on the 18th and then start the trial from there. I don't know how efficient we can be in terms of, but I mean, with 36 jurors, I feel like we ought to be able, if we start on time, to pick a jury that day and at least maybe get to openings that, in one day, maybe even a witness, but, that might be pushing it. So I just want to make sure you have an idea of the timing. Were there specific issues that the parties wanted to bring to it is a CPTO. The parties were able to work through it. And I do believe I have the most current version that has everybody's confident is the correct exhibit list they wish to submit and all that good stuff. Any questions, challenges, issues related to the court's entry of the CPTO from the plaintiff, Mr. Henderson?
No, Your Honor. I would say that sort of as we're forecasting what would move forward, I think that the most helpful thing in terms of our ongoing discussions from the court would be to sooner rather than later have a determination as to how the court plans to handle the issue of consequential damages.
Okay.
Our contention is that we're allowed to present that evidence, that the jury has wide latitude regarding that issue. And I think that the amount of evidence that's going to be allowed there and the court's scope on that will shape our ongoing discussions in perhaps the most meaningful way. So if we have time beyond sort of there's the preliminary parts of the PTO to get to that issue, I think would be the most helpful for the parties.
Okay. Thank you for flagging that, because I do try to prioritize the ones that actually are maybe outcome determinative, that kind of thing. Mr. Varghese, what about from the defense's perspective?
I'll allow my colleagues to correct me if I've got this wrong, but I don't think we have any objection to the entry of the PTO.
Okay. Okay, so any questions? So then once we get off the call, I will go ahead and enter the pretrial order. I will endeavor to, I had done a brief scan of the motions in limine, so I was aware of them. And I did see the issue of the consequential damages. And so I will take a look at that issue and see if I can get my hands around it and try and give you guys some guidance on that issue beforehand. Mr. Varghese, I know that typically motions in limine are something that we would be arguing orally, but to the extent briefly, if the city wishes to respond specifically to that issue in writing, I think that would be helpful. But I'm literally talking about, I think Mr. Henderson's presentation on that topic was maybe a page. And so I would, or maybe I've got it the other way around. Maybe it's that the city's motion in limine saying it's about a page long. It's Mr. Henderson. Thank you. I apologize. It's a lot of emails in my inbox. Anyway, Mr. Henderson, and so I have that backwards. If you wanted to, in very brief format, a page or two, point me to some cases that I should consider in responding to the city's argument that consequential damages are not allowable, because I think that is the procedural posture that we are in currently. And I will see if I can look at that issue.
Your Honor, if
Your
I
Honor,
may.
Okay, hang on. Mr. Ash?
Sorry, I'll defer to my colleague, Mr. Varghese, unless he doesn't say what I think he should say now, and then I will ask for an opportunity to supplement it.
But my colleagues have reminded me that I've forgotten one issue in the PTO, which is petitioner asserts that it intends to take a deposition of a fact witness for the city, as well as a 30B6 deposition of the city. And I'm just going to point the court to the famous precedent of Goose v. Gander, because I remember someone telling the court that the opportunity to take discovery has long passed. If they want to subpoena the witnesses to come to trial, they certainly can, but they're not entitled to any additional depositions at this point.
Mr. Henderson?
Your Honor,
Are these
previous-
Rule 24 notices to preserve testimony for trial?
No, Your Honor. These are depositions that we properly noticed. They just haven't been taken. And so they were properly noticed within the time frame in the discovery process. They just haven't occurred yet. And
Well,
so
hang on.
I don't think this is quite Goose v. Gander, Your Honor. I think this is a situation where what I heard in the prior ruling was this is something that is statutorily allowed. The fact that discovery is closed doesn't sort of change the statutory allowances here. And we would argue the same. We served the notice properly during the discovery period. And we simply haven't been able to conduct the depositions yet because they were continued. And so I don't see the issue.
May I respond, Your Honor?
Hang on. So how is it that how is it that it's your position that you served the deposition properly, the notice properly during the discovery period? I mean, discovery has been closed in this case for, I don't know, 6 months now. I mean, didn't this case went up on appeal after I granted summary judgment after the discovery period was closed? I mean,
these were served by prior counsel before we even came onto the case, Your Honor. They were served in the initial round of discovery. The deposition, I apologize. The depositions simply did not take place because they were continued as a result of the other sort of bizarre circumstances of the case. But this isn't any different than when you notice a deposition, agree to continue it to some future date, discovery closes during that period, you still get to take the deposition. The notice was properly sent. I don't understand the objection.
I mean, although the state procedure rules are not as clear as the federal procedure rules, I'm not exactly sure I agree with you that just because you notice a depo, certainly the parties by agreement frequently do that, but generally the rule of discovery being cut off is that the court's not going to enforce or support, compel efforts to conduct discovery after the close of discovery. And I feel like if the plaintiff wishes to exercise its evidence rights to preserve evidence for trial and to compel individuals to appear for trial, then they are free to do that. But discovery is long closed and we're not engaging in discovery anymore. Like I said, if you want to preserve evidence for trial or compel individuals' appearance at trial, you're free to do so.
Understood, John.
Okay. So, Mr. Henderson, where I ended before we started talking about that issue was I was going to give you, I mean, today is Thursday, but I was going to give you, and just maybe till tomorrow, just very briefly to point me to some cases that you believe support the position that the consequential damage is evidence that you wish to present relative to the city and the inverse condemnation claim. That I should take into consideration, and I'll endeavor to try and give you all some guidance on what the court's likely ruling is going to be on that topic, if it is helpful to the parties' continued efforts to potentially resolve the case short of trial. Beyond that, I will go ahead and enter the CPTO, and then my question is, do the parties have any questions regarding procedure, et cetera, in terms of what they can expect at trial?
One more question from us, Your Honor.
Yes, Mr. Henderson.
Going back to the sort of issue of who's going to be presented, you'll see in the CPTO that the city is now alleging that they are able to call a rebuttal expert. That expert was not noticed as is appropriate during the discovery period. My understanding is the city's argument is, well, we didn't know what expert you were going to present, so our rebuttal expert is in rebuttal to the new expert that you've named. I think going back to the court's earlier reasoning, the fact is that we did notify them of an expert. They never did any discovery to figure out what that expert's opinion was or how it would be rebutted. So They could certainly have filed notice of a rebuttal expert within the statutory timeframe of the Civil Practice Act. They didn't do so. We've received nothing regarding this expert, not anything about his opinion, how he formed it. And I think that it's inappropriate for that witness to be able to be called at trial again, especially given the court's rulings that, as the court has said, discovery is long closed. There's no ability to reopen for those sort of factual matters. And so I don't think it's appropriate to allow a late addition rebuttal witness
So one question I have is that my recollection is that Shine served discovery on the city that the city did answer. Is that correct?
Yes, Your Honor.
Okay.
And we asked for disclosure of any expert who was going to be called regarding that, and no expert was named. No rebuttal notice of an expert was filed. None of those procedural things occurred. So this is just a new witness that they're trying to add. This is no different than adding another expert for the city at the last moment and trying to sort of include them when no notice was provided.
Response, please.
Yeah, Your Honor. Shine is not using the expert they disclosed in 2024. I think they might have more.
I remember us discussing that the last time we were together.
Literally a week ago. So they hired someone new, and they only disclosed that person's name to us this Saturday and his bottom line number. That's all we got. So if disclosing a new expert more than a year after the deadline is permissible, then us disclosing an expert 3 days later than that can't be wildly forbidden.
So, sorry to stop you, Mr. Ash. The reason I'm comfortable stopping you, though, is that I generally agree with you, right? So here's the thing. We are trying this case as if we were all in the 1960s, right? And nobody's going to find out what anybody's going to say and who any of the witnesses are until we get to trial. Mr. Henderson, your point would absolutely be correct and well taken if you were using the same expert that had previously been intended to be used. But
Can I make one comment on that, Your Honor?
Hang on. I believe our prior discussion when we discussed this the last time we were together was that to the extent that you were identifying somebody new, that the city was entitled to get some information about who that was. And I understand you have endeavored to provide them with that information. And I think in that factual posture and added to the issue that generally speaking, the remedy for a late disclosed expert is to allow time to figure out what that expert's going to say. And since both of y'all are operating with the equivalent of 3 or 4 days of notice as to these two experts, I don't see the prejudice or why the court should not, going back to our Goose v. Gander standard, if I strike their expert, why not strike yours? But and my point in saying that is that the answer isn't generally to prohibit the discovery. It's just to allow the parties to try and get up to speed. Now I'm done, Mr. Henderson. Go ahead. I'm sorry.
No, it's your courtroom, Your Honor. I'm sorry for interrupting. I think the difference is that the logic we used the last time when we objected to them being able to depose the witness or anything like that is that there's no substantial difference in the amount of information they had. They just had 2 different names. They never deposed our prior expert. They never asked for his report. They never asked for the basis of opinion. They served no discovery at all. So nothing is different for them. They knew there was going to be an expert. They didn't obtain an expert and didn't notice it for that. So we are substantially changing the scenario in a real way for the defendant now by saying, okay, well, the city's also going to bring an expert. And we're not going to tell you what his opinion is or what he has to say or how he reached that basis of opinion. We're just going to get to call him in rebuttal, even though there's been no effective notice during the discovery period. So I don't think they're equivalent, Your Honor. I think if the logic is going to be internally consistent about the rulings we've had so far, which to the court's credit, it certainly has been, I think we end up in a position where the answer is you knew there was going to be an expert. You didn't choose to notice that there was going to be some rebuttal expert at that point. There shouldn't be one now. I would agree if I was saying, well, they've changed rebuttal experts, Judge, this isn't fair. But that's not our argument. Our argument is they had a statutory time frame to notice that there would be some rebuttal expert. We met our burden and noticed there would be some damages expert. And while that person has changed, it didn't prejudice anyone. But this is a prejudice. This is a real change in the grounding and in the footing of the case in a meaningful way that we didn't have any ability to do discovery on or to work through.
I understand. I still don't think that the answer is to strike or prohibit discovery, or I'm trying to stay away from that word, but to prohibit the use of a late disclosed expert. Like I said, even in this procedural posture, and I'm not saying that your logic doesn't hold, Mr. Henderson, but given the change in expert by the plaintiff, even if the plaintiff's perspective, and it may prove true, is that you had disclosed an expert and you simply changed your expert, et cetera, I still think that all things being equal, given that the general answer to a late disclosed expert is not to prohibit the expert, but merely to attempt to mitigate the prejudice by allowing the parties to get up to speed on what that expert's going to say. And I think that everybody is in something of the same position, which is the city just found out who your expert is and you just found out who theirs was. And we're going to go forward from there with that. Okay.
Then, Your Honor, I just request that we be given the same courtesy the city was, and we be informed of the expert's opinion as to valuation. We be provided with what we provided the city with last night, copies of the expert opinion and report, any documents that were relied on to reach it. There isn't parity here. It's not like we've shared the same amount of information. We've disclosed our expert's opinion at the time the court told us we needed to. We've transferred all the documents that it was based on, as well as the expert's report.
I'm sorry, Mr. Henderson, I didn't mean to cut you off. I was just going to say, I'm happy to confer with you further. I'm happy to provide you with the equivalent of what you provided with us as soon as I have it. I don't yet have an opinion from the expert. I'm happy to engage in a reciprocal exchange of information. And if, one of us is unhappy at the end of that, we certainly know how to get in touch with Mr. Fryhoff.
Okay. So anything else regarding procedure, et cetera, in terms of jury selection procedures or anything else? Because I do need to get moving.
The only other piece I was going to say, Your Honor, was on the in limine motions. We did file the briefs about our view on consequential damages.
Yes, sir.
And there is back and forth. Both have a truncated version of that in the PTO. I just want to be clear, though, that it's not the city's position that consequential damages per se aren't permitted. It's just that they are a very narrowly circumscribed set of them in the inverse condemnation world, as opposed to in the tort context generally. That's it.
Okay, excellent.
Your Honor, I do think,
yes,
if you could just high level talk about how you do voir dire and how long you'd provide the parties for openings and closings, just help us prepare.
So as long as you don't go on and on and on, I'm not going to put any limits on your ability to conduct the opening that you think is necessary for your case. I will tell you that I generally try very, very hard to let the lawyers try their case, and I'll rule on objections, et cetera. And sometimes I might call you up and be like, hey, the jurors' eyes are glazing over. Let's maybe move on. But I'm not going to do that in front of the jury. In terms of voir dire, I also endeavor to let the lawyers make friends with the jury and put on all the charm that they wish to try and put on. I will ask some initial questions just to make sure that they're minimally qualified, and that they don't know me or y'all, or, people that work with me, people that work with y'all, that sort of thing. And beyond that, I generally hand it over to the lawyers. The only thing I do ask is, and we can talk about what the lawyers prefer, because I'm happy to do it either way. But civil jury selection often is, I ask all those preliminary yes or no's, and then the lawyers will stand up and ask all these questions. And then, oh, juror number 12, you said yes to this question. Let me ask you about that and have a conversation. That's not typically how we do it on the criminal side. And I find it is a little more efficient, which is for y'all to ask those yes or no questions, make notes, and then follow up with the jurors at a different time to ask those narrative form individual questions. Y'all can talk about which you prefer. I am not married to either one. But the point is, however we do it, I will ask some initial yes or no minimal qualification questions. Do you live in Fulton County? You know, those sorts of things. And then beyond that, I will say, you guys ask the questions that you want within reason, and let's not be repetitive. And I also have been known to tell lawyers, you are entitled to a minimally qualified jury. You are not entitled to the perfect jury. So go from there. Anything else, Mr. Varghese?
No, thank you, Your Honor.
Okay, excellent. The only other thing I will suggest to you is we use Zoom rooms for evidence presentation. And so I would please ask you to pay very close attention to how you will actually present your evidence at trial. I will suggest to you that you likely need a paper copy of your documents, and here's why. Although it is technically possible to only put on the screen of the witness stand and the judge and the lawyers a document for foundational identification purposes, it is difficult to do technologically, and I have found it to be quite clunky. And this is a case where we likely are going to have to engage in that foundational, you know, set of questions for literally almost every document that's going to come into evidence, because there hasn't been this, oh, it was produced in discovery and blah, blah. So for that reason, I would suggest to you that this is a case where you may want to have a physical set of paper documents to show the witness for identification purposes, to lay your foundations and get those documents in. And then once they're in, you're free to throw them up on the big screen by sharing your screen in Zoom, and it will be on a giant board in front of the jury so they can see it. The witness stand also has a touch screen. So like if you wanted to ask the witness to circle something on a picture or on a map or something like that, you could ask them to do that and it all works. If you want to get with Mr. Freehoff and ask about a time that you could come in and familiarize yourself with the technology, you're also free to do that. Anything else?
Thank you, Your Honor.
Okay, excellent. Thank you all very much. I will get the PTO on file for you guys, and I will see you on the 14th of November.
Is there a time for that, Your Honor?
It's going to be 9, I'm sure.
Okay.
9 o'clock.
Thank you.
Yes, Madam Court Reporter?
Yes, before we hang up, I did have a question, but I'll go at the very tail end of everything.
No, we're completely done. So
We're done. One thing that I should have asked before we even started this PTO is, were the parties want to share and take down?
Mr. Henderson?
Yes, Your Honor.
I'm sorry.
I think we asked for the court reporter, so I know I'm on the hook.
Mr. Henderson?
Okay.
Well, as much as I hate to do the city a favor, we'll share in the cost, I suppose.
Okay. All right. I just
Only if you want the transcript.
I am actually dealing with a case right now where someone has invoked that and said that they didn't share and take down, so they can't have a transcript. So thank you for being very professional and civil and working through that. But you are all free to go. Have a good day.
Thank you, Your
Thank
Honor.
you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Hi, Ms. Lyle and Ms. Hood, are you there?
Yes.
Hi. So I have you guys down for a motion for summary judgment hearing in the matter of Marvis Johnson versus MARTA.
Yes, Your Honor.
I have a very short window. I have a criminal calendar that I need to go call at 10:30. And I apologize that the other matter went on for some time. But my intention had been to provide you guys with about 15 minutes each side. It feels like it's a fairly straightforward presentation, even if, of course, the issues are never as clear as we want them to be. Does that seem reasonable in terms of 15-ish minutes?
I need 5, Your Honor.
Oh, okay. What about you, Ms. Hood? I assume you are not on my piece of paper as counsel, but I assume that you are here on behalf of MARTA. Is that right?
Yes, Your Honor. I'm here.
You're here on behalf of MARTA, Ms. Lyle, and Ms.
Yes.
Hood, you're here on behalf of Marvis Johnson, right?
Yes.
Okay. And Ms. Hood, are you going to be?
Oh, short, about 5 minutes.
Okay, well then let's just go. I appreciate you ladies for being very prepared and efficient.
Perfect. Although I don't want to get in trouble now if I do go over, but
No, but also I will let you know, I have read both the motion for summary judgment, the supporting documentation. Thank you very much for Ms. Hood for your office's response to both the briefing, but also to the admit, deny, et cetera, of the assertions of fact. And so that makes it easier for everybody. So let me say, to make it easier, I am aware that this is a slip and fall where unfortunately poor Mr. Johnson slipped and fell on a step at MARTA, and then subsequently, I believe, was diagnosed with pancreatic cancer and has just had all sorts of problems. And my heart just goes out to him. But this, of course, is primarily an issue of, before you get to the causation aspects of it, an issue of the nature of whether there is evidence to create a disputed issue of fact as to the hazardous condition and any knowledge that MARTA may have had about the existence of that hazardous condition. So go, Ms. Lyle.
all right. And Your Honor, keeping it very briefly, I think the first thing I do want to point out, no actual knowledge. And I think that's important to point out because while in the response to the statement of facts, plaintiff refutes that statement in their own brief, they have a section titled defendant had no actual knowledge. So I think by virtue of that, that should be kind of an easy check mark that there was no actual knowledge, which means we now move on to constructive knowledge. And like Your Honor said, you've read all of our briefing. There's just simply no evidence that there was any constructive knowledge. We understand plaintiffs spent some time briefing the issue of plaintiff's own actions, but what we will point to is that we don't get there. Citing the case that plaintiffs, I think primarily, maybe only cited the Robinson case. First, there has to be knowledge that defendant, or rather evidence that defendant was negligent. Once there is that evidence, we move on to determine whether or not plaintiff acted in a reasonable manner. So our position is that there's just no evidence to establish any constructive knowledge. The prongs are very well laid out. And that's our only burden at this stage, is the lack of evidence in the record. So there's nothing that plaintiff can or did point to show that there was constructive knowledge for us. Again, our reading of the law is that before we even get to the lack of ordinary care, Robinson plainly says that defendant has the evidentiary burden to the issue of plaintiff's negligence after it has been established or assumed that defendant was negligent. So we haven't even gotten there yet to examine plaintiff's negligence. So that's our position. There is a lack of evidence to show our constructive knowledge. Thereby, we don't even get to that second portion that they're exploring. And that's not our argument. Our argument is not whether or not plaintiff was negligent. There's just simply no evidence to that. And then one of the other points that we made was the negligent hiring. I don't know that plaintiff addressed that in their brief. And again, we contend that there's just not any evidence to show there was any negligent hiring on behalf of MARTA. Therefore, that should be granted.
So given that we don't, as I understand it, the parties don't really know how we have evidence from Mr. Johnson that a hazardous condition existed, right? Because he says there was some liquid that he slipped on. But my understanding from your record is that there's really not any evidence of how that condition came to exist, or any employee that might have either caused it to be there or whose job it might have been to make sure it wasn't there or to check to see if it was there. Is that an accurate statement of the record?
For the most part, Your Honor, I believe there was a 30B6 who did explain that they do have some procedures for viewing it.
Right.
There has been no evidence to dispute that.
Okay.
And again, and I think our position is also that plaintiff's claim is just simply not enough.
Okay. Well, I mean, plaintiff's claim that a hazardous condition existed is evidence that a hazardous condition existed. The question is, in slip and fall, the question always is, how did that condition come to exist? And it doesn't sound as if MARTA's arguing that it didn't exist. They're saying MARTA had no responsibility in creating it or obligation to, or circumstances which would imply that it should have located it and remedied it.
Correct, Your Honor. And then again, we point simply, as we have to do at this stage, the lack of evidence on the record.
Understood. Thank you, Ms. Lau. Ms. Hood, your response?
Yes, as stated in our brief, that we do not, of course, have evidence of actual knowledge, such as video footage of showing a MARTA employee or the timing, but our argument is that the defendants cannot establish a reasonable procedure required to prevail as to constructive knowledge. There is no evidence. They, in general, in their brief, stated that the substance was not present on the stairs long enough to establish that it should have been discovered by MARTA, but as stated in previously by the 30B6 deposition, the defendant admitted that there are cameras located throughout the MARTA station, but there is no one watching the cameras live. They do not have a schedule of walking the premises to check for cleanliness. The defendant was asked, how often does the station maintainer check the premises for cleanliness? Essentially, it just depends on the activity of the station. So essentially, they will walk the premises if a large group of people go through the station, but they do not have a set procedure to prevail as to constructive knowledge.
Okay. Talk me through that a little bit more, Ms. Hood, in terms of, so if I understand your argument correctly, it is that in order to refute a constructive knowledge argument, right, that MARTA is obligated to demonstrate they have a procedure and that they failed. And here's why I'm asking. I agree potentially that if MARTA has a procedure and there's evidence that they didn't follow their procedure, that can be evidence of potential constructive knowledge, or they knew or should have known, and that's something that might get you past summary judgment. But I think what I heard you say is that they are obligated to have a policy or procedure and they didn't show one, and I'm not quite sure I followed that. Can you clarify that for me?
Yes, my argument is to prevail at summary judgment, the defendant must show that its inspection procedure was reasonable and that it was carried out at the time of the incident. That's via Shepard v. Wynn.
Mm-hmm.
And the defendant has not provided that, number one, that they had a reasonable inspection procedure and that it was carried out at the time of the accident. They have provided no evidence that a certain amount of employees walk the premises, how often they walk the premises that day. Is just, in general, they do not possess any video footage of the incident. Therefore, their argument is that they're entitled to summary judgment. We're stating that they have not proven enough to overcome summary judgment, that they had a reasonable inspection procedure and that it was carried out at the time of the incident.
Okay. Okay. Thank you, Ms. Hood. Anything else?
No.
Okay. Ms. Lyle, it's your motion, so you get the last word.
Yes, and I forgot to mention just on the piece of the medical causation, Your Honor.
Yes.
As I understand, so our position is very simply the cancer and cancer treatment was certainly not a result of plaintiff having that.
Let me stop you there. That's going to be an evidentiary issue in terms of the caliber and nature. If the case survives summary judgment and goes to trial, then yes, we're going to have a conversation about the extent to which the plaintiff can offer evidence related to cancer treatments and anything else. As I understand, for me, the relevant causation issue is there evidence in the record as the necessary type of evidence to demonstrate the back injury and surgery that flowed from this fall when there is some evidence that there were other falls during the time period, and also that he had pancreatic cancer that was discovered during the surgery?
Thank you, Your Honor. You made that a lot more succinct than I could have. And so our point is, like what? So first, the whole cancer, and I only mentioned that, Your Honor, because in plaintiff's response, they said they did not submit bills that were related to cancer. So I was going to suggest, to make that issue even better, we can parse them out, you know, for the court or for plaintiff, and show these are all bills that say oncology treatment. Therefore, they're not related.
Okay.
And then to your point, there is multiple subsequent falls. The medical records are ripe with that. And there is nothing in the medical records which say this fall versus this fall is the one that caused a fracture or the issue.
Sure, and I understand that. I will say this, I think that the issue of the knowledge and whether there was an obligation, a duty, what duty was satisfied or not satisfied, and the relative knowledge of the two parties, that's where I'm going to focus my attention, because I understand why you asserted that in a motion for summary judgment, but the fact that there were multiple falls and a pathology of cancer that were going on at the same time, assuming that there will be testimony from someone that this injury was the result, that this fracture was the result of insert answer, cancer, fall 1, fall 2, fall 3, those are definitely, in my opinion, disputed facts that a jury would have to decide what they believe. And I don't think that's going to be dispositive for summary judgment purposes. And so I understand the argument, but that's not, I don't think that's really going to win the day here. What I'm going to do is focus my efforts in a little bit more review of the knowledge aspects that were presented by each of you today. And then again, I want to go back and look at the statement of undisputed material fact and the plaintiff's response to that.
Understand. Thank you, Your Honor.
Listen, I really appreciate your patience with me while I was plowing through that other issue. I really appreciate the efficiency with which you have presented your issues. And I will endeavor to get you a ruling. Just so you know, what I typically do is I will email the party, or actually Mr. Freehoff, my staff attorney, will email the parties and say, hey, the judge has decided that the motion is granted or the motion is denied, and will give you some insight into the basis for my ruling, and then ask that the prevailing party prepare such a motion or proposed order for me that I can then edit. So that's likely what you can expect in terms of a ruling. Okay.
Understood. Thank you, Your Honor. Appreciate your time.
Okay. Thank you. Any questions for me about what will happen next, or anything else that you need from me today before we log off?
No, Judge. Thank you.
Okay. Excellent. Have a good day, both of you.
Thanks. You as well.
Bye-bye.